Okay.
Good afternoon, everybody. Today, we will be presenting the legal aspects of sexual abuse. I am Alexander D. Espino Jr., along with my groupmate Jones Curvy Demanda. Our contents will be number one, definition of sexual abuse, number two, examples of sexual abuse, number three, effects of sexual abuse, number four, the law in terms of sexual abuse, number five, conclusion, and number six, references. What is sexual abuse? Sexual abuse is a form of sexual violence, which is any sexual activity without any consent. Other forms of sexual violence are sexual assault, such as rape and unwanted touching, and sexual harassment, which is unwelcome sexual behavior. Examples of sexual violence are being used sexually in a way that is humiliating, being forced or coerced to have sex without protection from sexually transmitted diseases, sexual photos or videos being posted online without your consent, being coerced, threatened, or forced to perform any sort of sexual activity, being spoken to in a sexual way that you find offensive or degrading, repeated unwanted sexual attention or advances, including in your workplace or by your employer. Someone making degrading or offensive comments about your body or sexuality, or using sexual terms and language in a way that makes you feel uncomfortable. Experiencing an attempted rape or sodomy. The effects of sexual violence are feeling as if everyone could see what happened to you, engaging in self-harm or self-mutilation, an urge to use alcohol, drugs, or gamble excessively, feeling unsafe and scared that it would happen again, a decline in your physical and mental health, not being able to fall or stay asleep, feeling overwhelmed with a range of emotions like anger, fear, or numbness, changes, either loss or increase in your appetite. These are just ways that a person might cope with the trauma that have happened to them. The law in terms of sexual abuse. Republic Act Number 8353, the Anti-Rape Law of 1997, is a Philippine law that aims to provide stronger protection against rape and sexual assault. It redefines and broadens the scope of rape, emphasizing that it is a crime committed primarily against the victim's consent rather than focusing on the means or force used. The new law reclassified rape from crime against chastity to a crime against persons, which means that prosecution is commenced in court by the filing of an information by the public prosecutor and no longer by a mere complaint by the offended party, parents, godparents, or guardian. Rape may now be committed against men, not only against women. Rape is committed by any person who shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. Any physical overt act manifesting resistance against the rape in any degree from the victim is admissible as evidence of lack of consent. Tenacious resistance, however, is not required. Neither is a determined and persistent physical struggle on the part of the victim necessary. This law also establishes harsher penalties for those found guilty of rape, including life imprisonment or death penalty if a certain aggravating circumstances are present. Additionally, it recognizes marital rape as a criminal offense and provides support for victims, including protection measures and legal assistance. This law represents an important step in addressing sexual violence and protecting the rights of victims in the Philippines. Article 266-B Penalty. Rape under paragraph 1 of the next preceding article shall be punished by reclusion perpetua. Whenever the rape is committed with the use of a deadly weapon or by two or more persons, when by reason or on the occasion of the rape the victim has become insane, when the rape is attempted and a homicide is committed by reason or on the occasion thereof, when by reason or on the occasion of the rape homicide is committed, the penalty shall be death. The death penalty shall also be imposed if the crime of rape is committed with any of the following aggravating/qualifying circumstances. Number 1. When the victim was under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree. or the common law spouse of the parent of the victim. When the victim is under custody of the police or military authorities or any law enforcement or penal institution. Number 3. When the rape is committed in full view of the spouse, parent, or any of the children or other relatives within the third civil degree of consanguinity. Number 4. When the victim is a religious engaged in legitimate religious vocation or calling and is personally known to be such by the offender before or at the time of the commission of the crime. Number 5. When the victim is a child below 7 years old. Number 6. When the offender knows that he is afflicted with the human immune deficiency virus, HIV, acquired immune deficiency virus syndrome, acquired immune deficiency syndrome, AIDS, or any other sexual transmissible disease and the virus or disease is transmitted to the victim. Number 7. When committed by any of the armed forces of the Philippines or paramilitary units thereof or the Philippine National Police or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. Number 8. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. Number 9. When the offender knew of the pregnancy of the offended party at the time or of the commission of the crime. When the offender, number 10, when the offender knew of the mental disability, emotional disorder, and or physical handicap of the offended party at the time of the commission of the crime. Article 266-C Effects of Pardon. The subsequent valid marriage between the offended party shall extinguish the criminal action or the penalty imposed, in case it is the legal husband who is the offender. The subsequent forgiveness by the wife as the offended party shall extinguish the criminal action of the or the penalty, provided that the crime shall not be extinguished or the penalty shall not be abated if the marriage is void ab initio or annulled. Article 266-D. Presumptions. Any physical overt act manifesting resistance against the act of rape in any degree from the offended party, or where the offended party is so situated as to render her or him incapable of giving valid consent, may be accepted as evidence in the prosecution of the acts punished under Article 266-A. However, even though Article 8353 imposes the death penalty, because of Republic Act Number 9346, an act prohibiting the imposition of death penalty in the Philippines, the death penalty cannot be imposed. In Section 1, the imposition of the penalty of death is hereby prohibited. Accordingly, Republic Act 8177, otherwise known as the Act designating death by lethal injection, is hereby repealed. Republic Act Number 7659, otherwise known as Death Penalty Law, and all other laws, executive orders, and decrees, insofar as they impose the death penalty, are hereby repealed or amended accordingly. Section 2. In lieu of the death penalty, the following shall be imposed. A. The penalty of reclusion perpetua when the law violated makes use of nomenclature of the penalties of the revised penal code. Or B. The penalty of life imprisonment when the law violated does not make use of the nomenclature of the penalties on the revised penal code. Section 3. Person convicted of offenses punished with reclusion perpetua or whose sentences will be reduced to reclusion perpetua by reason of this act shall not be eligible for parole under Act Number 4180, otherwise known as the Indeterminate Sentence Law as amended. Section 4. The Board of Pardons and Parole shall cause the publication at least one a week for 3 consecutive weeks in a newspaper of general circulation of the names of persons convicted of offenses punished with reclusion perpetua or life imprisonment by reason of this act who are being considered or recommended for commutation or pardon, provided, however, that nothing herein shall limit the power of the President to grant executive clemency under Section 19, Article 7 of the Constitutions. Section 5. This act shall take effect immediately after its publication in 2 national newspapers of general circulation. Now I will be handing the presentation over to my partner, Jones Kirby Dimandal.
Lex. Hindi ko ma-share yung screen.
Wait lang po.
Good afternoon. Naririnig po ba ako, Doc?
Yes, thank you.
Yes, sir. Hi, Doc.
Mm.
So, I'm Jones Kirby Di Maandal and I'm going to continue the report of legal aspect of sexual abuse. So, before that, sir, good afternoon. And before I continue, sir, may katanungan lang po sana ako.
Yes.
Do you still recall these cases? So, in 1991, the people of the Philippines versus Alberto Torrevillas Abalarao.
Sino bang dependent dyan?
Si Abalaraw po. And then in 1995, si Pacifico Lazaro Repiso.
Itong pangalawa, parang
Naalala niyo po.
nalimutan ko na.
So in 1999 po, si Rolando Alfanta Alo.
Ito yata yung babaeng nabuntis. No?
Yes, yes, Doc.
Oh,
And then in 2000, si Ernesto Garchitorena.
ito yung bata naman.
Yes, sir. And then in 2002, si Richard Dioona.
Latest ito, hindi ko pa nakikita yung
Yes.
decision dito.
Aba.
Lahat yan dumating sa Supreme Court, ano?
Yes po. And then si Clement John Ferdinand Navarrete.
Ito rin.
So, all of the aforementioned cases are rape case, and Dr. Noel Minay, APSP, was the one who carried out the medical legal examination. Additionally, he was called as an expert witness during the trial, and one of the major elements that contribute to the case's resolution is the testimony he provides. So, lahat po yun is may decision na. And upon reading all those cases, so yung testimony niyo po kasi yung naging vital in para magkaroon ng finality yung case. And madami pa po kasi hindi ko na kayang basahin lahat eh. But anyway, just to share to the class na how great you are.
Hindi, ano lang. Exposed lang ako sa court appearance din. Aside from autopsies, saka mission sa all over the Philippines.
Yes sir, hindi pa kasama niya yung autopsy, yung mga airborne
Wala pa
murder
dyan.
cases. So, the law in terms of sexual abuse. So, distinguish the fire rape law under revised penal code and the new rape law under 8353. So, just to give a history po kasi, yung rape law po kasi natin is napasa lang 1997. And before kasi ang crime of rape was under the Crimes Against Chastity. And then the 8353 amended the provision in the RPC relating to the rape and had been reclassified and placed under the Crimes Against Person. So RA 8353 did was define rape and how it's committed and how impose penalty. But after the passing and implementing the said law, a question arises on what the government can do to help and assist the victim of rape. Hence, Republic Act 8505 was created in 1998, a year after passing the Republic Act 8353. So, 8353 and 8505 go hand on hand. So, Republic Act Republic Act 8505 is an act providing assistance and protection for rape victims, establishing for the purpose of a rape crisis center in every province and city, authorizing the appropriation of funds therefore and for other purposes. So, this is what under the Rape Victim Assistance and Protection Act of 1998. First is the declaration of policy. The act declares the policy of the state to provide necessary assistance and protection for rape victims by coordinating government agencies and non-government organizations to establish and operate a rape crisis center in every province and city. And rape crisis center. So ito yung mga departamento ng gobyerno kung dapat mag-a-assist sa rape case versus the Department of Social Welfare and Development, Department of Health, Department of Interior and Local Government, Department of Justice, and lead non-government organization, which is the NGO. Will establish a rape crisis center in every province and city. This center will provide services like psychological, counseling, medical examinations, legal assistance, and support for rape victims and their families. Duty of the police officer. Police officers are required to refer rape complaints to the prosecutor for investigation or inquest, arrange for counseling and medical services for the victim, and maintain the privacy of the victim during examinations. Women desks are to be established in police precinct to handle cases involving women rape victims. Protective measures. The Act emphasizes the right to privacy for both the victim and the accused during the investigation, prosecution, and trial of rape cases. Closed-door proceeding may be ordered to protect the identities of the parties involved, and proceeding can be conducted in a language or dialect known to the parties. Rape shield. Evidence of the complainant past sexual conduct or reputation shall not be admitted in rape prosecution unless it is deemed material and relevant to the case. Appropriations. Initial funding of 120 million pesos allocated for the establishment and operation of rape crisis centers. Subsequent funding will be included in the Annual General Appropriations Act. Separability clause. In any part of the act is declared invalid or unconstitutional, the other parts remain valid. Repealing clause. Laws, acts, decrees, orders, and regulations inconsistent with this act are deemed amended, modified, or repealed accordingly. So, even though napasa naman yung 8505, so madami siyang challenges and issues pa rin. So, the Rape Victim Assistance and Protection Act in 1998 in the Philippines addresses a crucial issue by providing assistance and protection for rape victims. However, like any legislation, there can be potential challenges or issues that may arise in its implementation. Some of the potential problems or challenges associated with those are resource allocations. While the law authorized the appropriation of funds for the establishment and operation of rape crisis center, the availability of adequate and sustained funding over the years may be a concern. Ensuring that the centers have the necessary resources to provide comprehensive support rape victims is crucial. Coordination among government agencies and NGOs. The law mandates coordination among various government agencies and non-government organizations, ensuring effective collaboration and non-communication among these entities may be challenging, and there may be bureaucratic hurdles that hinder smooth cooperation. Capacity building. Training programs for law enforcement officers, public prosecutors, lawyers, medical officers, social workers, and barangay officials are essential. However, ensuring that these training programs are consistently and effectively implemented may require ongoing efforts and resources. Privacy and confidentiality. Protecting the privacy and safety of rape victims is a priority as outlined in the law. However, maintaining confidentiality throughout the legal process can be challenging, especially when sensitive information needs to be shared with multiple parties involved in the case. Access to the services. Ensuring that rape victims, particularly in remote areas, have access to the services provided by the Rape Crisis Center may be a logistical challenge. Infrastructure and geographical factors could impact the reach of these services. Implementation and enforcement. Implementing the law's provision at the local level and enforcing the measures of it outlines may vary across different provinces and cities. Consistent enforcement and adherence to the law's requirements are essential. Another is sensitivity and awareness. Changing attitudes and raising awareness about the rights and needs of rape victims within the legal and law enforcement communities, as well as society at large, may be an ongoing challenge. Legal challenges. The law includes provision related to the admission of evidence regarding to the complainant's past sexual conduct. The interpretation and application of this provision in specific cases could lead to legal challenges. Budgetary concerns. Over time, as inflation and costs increase, the allocated budget for the Rape Crisis Center may become insufficient to meet the growing demand for services and support. Data collection and reporting. Accurate data collection and reporting in the number of rape cases, the services provided, and the outcomes of cases are critical for evaluating the effectiveness of the law. Ensuring that these data are consistently collected and reported may require additional efforts. So, yung topic naman kasing to is maikli lang talaga kasi umiikot lang siya sa dalawang batas, which is the 8353 and 8505. So, sa Pilipinas kasi medyo late pa rin kasi talaga yung pagbuo ng batas kasi imagine, ang rape law natin is naipasa lang nung 1997. And then yung law na nagpo-provide ng protection sa victim was passed 1998. So, ilang years lang siya. So far, itong 8505, nakikita naman natin mostly sa mga presinto ng police like the women's desk. So doon kasi lagi pumupunta yung doon dadalhin ng police yung may reklamo ng rape. And then yung police naman is automatic sasamahan siya para mag-conduct ng test kung totoo ba yung sinasabi niya o kiniklaim niya siyang rape. That is why sa start ng report, makikita natin na isa sa laging nagkakandak before kasi si Dr. Mina is under ng NBI as doctors. Siya yung normally that time 1991 and then 1995 kokonti lang yung reported. But after passing the law, dumami siya kasi nga may law na nag-a-assist sa mga rape victims. So, yun lang po.